Hello, you all. I welcome to read BRX with me. Now, just a quick info that the previous section, so I have uploaded two parts. The second part could not be recorded properly, and because of that, the previous chapter, I have half of investigation, that is part 9, and part 11, 12, 13 have not been recorded properly, so I will re-record them and upload it. But for now, let's start with chapter 14. It's miscellaneous provision, which we might tend to ignore, but there are certain important provision in this part as well. So let's get started. Section 66. Business transaction of partners with limited liability partnership. A partner may lend money to and transact other business with a limited liability partnership and has the same rights and obligation with respect to the loans or other transaction as a person who is not a partner. So in this section, it's just saying that a partner can transact with LLP as a separate entity. So if there is a person A who is a part of this LLP, so for example, if there is an LLP and there are partners A, B, and C, and A want to transact with LLP. So while he'll be transacting with this LLP, he will be doing so in his individual uh, capacity. So that way he would have, and there is some person D, he's an outsider, he would also be transacting with LLP. In that way, the rights that D would have, the same right will be accrued to A. So it says a partner may lend money and transact business with the LLP and has the same rights and obligation with respect to loan or other transaction as a person who is not a partner. Got it? Now, Section 67, application of the provision of the Companies Act. So, this is a very simple section, as the name itself suggests, that the provisions of Companies Act can apply to the LLP. Now, for the pre-perspective, what is important? Which authority would implement it? So, central government, by its notification, direct that the Companies Act will apply or apply with the exception or modification and adaptation as may be specified in the notification. So, authority, remember the authority is not the state government, it's not the registrar, it's not any other body. For example, it's not the LLP agreement by virtue of which the Companies Act provision will apply. So, it is the central government by its notification can apply the provisions of Com- Companies Act. It may apply it mutatis in the same way, or either it can apply it by providing some exception, modification, or adaptation. A copy of every notification proposed to be issued in subsection 1 shall be laid in draft before each House of Parliament while it is in session for a total period of 30 days, which may be comprised in one session or into one more successive sessions. And if before the expiry of the session, immediately following the session or the successive session, both houses agree in disapproving the issue of notification, or both houses agree in making any modification in the notification shall not be issued, or as the case may be, shall be issued only in such modified form as may be agreed upon by both the houses. And this is just the procedure. So what does this procedure say? So this procedure says the central government notification is not an executive action. It is not an executive action. What is an executive action? When the executive makes a decision, it makes a decision themselves. So we have a parliament, which is a legislative body, and we have our government, which is the executive wing, which is comprises of all the prime minister and all the majority party of the parliament. This is the government. There are some rules that have been made by these executive without going to the parliament. But here, while you are applying the Companies Act, all those modification of the draft of such notification to be led in the parliament. And this parliament, both houses will pass those notifications. Then only Companies Act will be made applicable. So it's a legislative act. It's not a executive act, which is which makes the application of Companies Act on the LLP. Moving forward, Section 67A, Establishment of Special Courts. Central government. Who? Central government for the purpose of why providing speedy trial of offence under this Act by notification establish or designate as many special court as may be necessary for any area or areas as may be specified in the notification. And the special court shall consist of a single judge holding office as a session judge or additional session judge in the case of offences punishable under this Act with imprisonment of 3 years or more, and a metropolitan magistrate or a judicial magistrate of first class in case of other offences, who shall be appointed by the central government with the concurrence of the Chief Justice of the High Court, provided that until the special court are designated or established under subsection 1, the courts designated as a special court in terms of section 435 of the Companies Act shall be deemed to be special court for the purpose of trial. Wait a second. Oh God, where is it lost? Okay, here. Provided further that notwithstanding anything contained in the Code of Criminal Procedure, any offence committed under this Act which is triable by the special court, until a special court is established under this Act or the Companies Act, be tried by the Court of Session or the Court of Metropolitan Magistrate or the JM1, as the case may be, exercising jurisdiction over the area. Now, what are to be remembered under 67A? First, which authority? Central government. Why? For the purpose of speedy trial. How it is being established by a, what is this happening? Wait a minute. Hmm. Okay. So the authority is the which authority? Why? Now, how many? It can designate as many special court as may be necessary. Then who would be the judges? So if an offense is punishable in more than 3 years, it would be the session judge or additional session judge. And if it is less any other cases, it will be the Metropolitan Magistrate or the JM1. Since we are reading this for the Delhi Judiciary Services, we have a Metropolitan Magistrate. So a MCQ can come in pre, which can ask who would take who would be holding a proceeding in a situation where LLP is involved and the offense is punishable with less than 3 years or involve fine, something on that sort. They may give a statement and then you have to pick which magistrate. Now, another thing, who would appoint these magistrates? It is important to note that in the CRPC, all the appointments are being done by the central state government in consultation with the Chief Justice of the High Court. But or actually in the CRPC, state government established the courts and appointments are done by the high courts. This is what the section 9, 10, all those provision talks about. But here, appointment is done by the central government with concurrence of the Chief Justice of the High Court. This is important. And now it says until such a special courts are being established, though all the proceedings will be taken under the special court which have been established under Section 435 of Companies Act. And if there is no special court being established under Section 435 also, then they will be tried by the Court of Session, Court of Metropolitan Magistrate, or Judicial Magistrate first class. This is it. So you remember central government, you remember the speedy trial के purpose से, you remember the courts, that is the session judge for the offense more than 3 years, and for other cases, Metropolitan Magistrate or GM1, appointment of judges by the central government with concurrence of Chief Justice of the High Court, and until the special court is being established, you go to the Special Court of Companies Act. If there is no such special court, then go to the normal court, or then the offense will be tried by the session court, Court of Metropolitan Magistrate, or the judicial magistrate first class. Now 67B, procedure and power of the special court. Notwithstanding anything contained in the Code of Criminal Procedure, all offences specified under subsection 1 of section 67A shall be triable only by the special court established or designated for the area in which the registered office of the LLP is situated, in relation to which the offence is committed, or where there are more than one special court for such area, by such one of them as may be specified in this behalf by the High Court concerned. So this provision gives overriding, notwithstanding, it gives overriding power to LLP Act over. So if it is overriding, which act has been overridden? It is the CRPC which is overridden, because CRPC is a general law. And the same thing has also been mentioned in one section of the CRPC. So there is one section of the CRPC which says that if there is any special law being made, then that special law will prevail over the CRPC. CRPC also makes such uh, declaration. It is section 5. So you can revise that also simultaneously. Now, it says for all the offences which have been mentioned in 67A, subsection 1. What are the offences mentioned? It says that the classes of offence for which the speedy trial is required, for those classes of offence, you establish the special court. So if we have some special court, then that special court would have the exclusive jurisdiction, and then you file a proceeding in a court which is established, which is designated for the, for example, if this is the place where the registered office of LLP is. In this area, this there are two, three special court under 67A. Now, if there is just one, you file to that special court. If there are more than one, then the High Court would make the rules regarding the jurisdiction, and then you file in the required special court. While trying an offense under, oh, where, what is this? Okay. While trying an offense under this act, a special court may also try an offense other than any offense under this act, with which the accused may, under the CRPC, be charged at the same trial. So what is this? So for example, a person commits some offense which is punishable under LLP. What are the offense? Commits fraud. That fraud is punishable under which section of this LLP Act? Check. Let's just check it. I think 30 it is. Unlimited liability in case of fraud. So section 30. Okay. So in case of, so for example, a LLP committed a fraud. The liability will arise under section 30, and fraud is also punishable under IPC. So there also the liability arise. So will you separate these two offences? Will you separate the proceeding under LLP and the proceeding which is start under IPC? It says no. The special court can try an offence other than the offence which are also under this act if the same trial is warranted. Notwithstanding anything contained in the CRPC, the special court may, if it thinks fit, try in a summary way any offence under this act which is punishable with the imprisonment for a term not exceeding 3 years. There is an offence which is punishable for 3 years. Now the special court can, for not exceeding 3 years, less than 3 years, the special court can try it summarily. And when it tries summarily, it cannot give a punishment for more than 1 year. It says, provided that in case of any conviction or summary trial, no sentence of imprisonment for a term exceeding 1 year shall be passed. Okay? Summary trial, 1 year only. Remember this, it's important. Provided further that when a commencement of or in the course of summary trial it appears to the special court that the nature of the case is such the sentence of imprisonment for a term exceeding 1 year have to be passed, or that it is for any other reason undesirable to try the case summarily, the special court shall, after hearing the parties, record an order to that effect and thereafter recall any witness who may have been examined and proceed to hear or rehear the case in accordance with the procedure of the regular trial. So you order, so you order a summary trial, but while you were while you were in the course of the summary trial, you find out that the nature of the case is such that the punishment for more than 1 year to be given, because there is a condition that you can't give punishment, that there's a limitation on the sentence which is 1 year. So if you have to give 1 year, more than 1 year of imprisonment, you cannot try it summarily. So this is one case situation where you can go back to a general or a normal regular trial. Second condition is for any other reason and undesirable to try, any other reason because of which the court thinks that it is undesirable to try the case summarily. Then, in that situation, also the court may order regular trial. And while it is going back to a regular trial, it can either recall any witness or it can hear or rehear the case. Okay, so this was section 67B. We started with section 66, where a partner can personally transact with LLP in an individual capacity. We went on to the application of Companies Act on the LLP by the central government. Then we dealt with the establishment of special court, the judge establishment and the appointment of judges to those special court. Then we discussed the procedure and the power of those special court, which is they have the exclusive jurisdiction. That is, they can also try an offense which is they can also try the other offense other than the punishable under the LNP Act. They have the power to try summarily under a situation where the offense is punishable with less than 3 years, and in that situation, the punishment can be given only for 1 year. In case during the course of such proceeding, if the court finds out that the nature of the case is such where the punishment of 1 year is warranted, or for any other reason, the court consider that it is undesirable to try the case summarily, then in that situation, the court can uh, revert to the regular trial, and while doing so, it can recall or rehear the case. Now, appeal and revision. High Court may exercise so far as may be applicable all the powers conferred under Chapter 29 and 30 of the CRPC on a High Court as if special court within the local limits of the jurisdiction of High Court were a court of session trying cases within the local limit of the jurisdiction of the High Court. So just remember that appeal and revision power lies with the High Court. Electronic filing of documents. Oh God, this is annoying. Electronic filing of documents. Any document Any document required to be filed, recorded, or registered under this Act may be filed, recorded, or registered in such manner and subject to such condition as may be prescribed. So we have seen under Section 34, 35, you are filing a lot of records like annual statement, annual returns, financial statements. Even the registrar asks you to submit so many documents. So they're saying it can be filed, recorded, or registered in a manner which are subject to condition as may be prescribed. A copy of or an extract from any document electronically filed with or submitted to the registrar, which is supplied or issued by the registrar and certified through affixing digital signature as per the Information Technology Act To be the true copy of the extract from such document shall in any proceeding be admissible in evidence as of equal validity with the original document. So it's giving the validity to our electronic documents. Any information supplied by the registrar that is certified by the registrar through affixing digital signature. Any information supplied by the registrar that is certified by the registrar through affixing digital signature to be a true extract from any document filed with or submitted to the registrar shall in any proceeding be. So this is with respect to a document submitted to the registrar, and clause 3 is with respect to any document which the registrar is giving. What are the documents that registrar give? Registrar gives certified copies, certification of registration, etc. So this is this, and this is saying they are admissible in the evidence unless evidence to the contrary is adduced. Very simple, nothing to be remembered much. 68A Registration Office. For the purpose of exercising such power and discharging such function as are conferred on the central government by under this act or under the rules made thereunder, and for the purpose of registration of limited liability partnership under this act, the central government shall by notification establish such number of registration officers as at such places as it thinks fit, specifying their jurisdiction. Central government may appoint such registrar, additional registrar, joint registrars, deputy registrars, and assistant registrars as it considers necessary for the registration of limited liability partnership and discharge of various functions under this Act. The power and the duties of registrar referred to in subsection 2 and the terms and conditions of their services shall be such as may be prescribed. Central government may direct the registrar to prepare a seal or seals for the authentication of documents required for a connection with the registration of limited liability partnership. Easy section 68A just says that the power lies with the central government to establish the office of registrar. The central government has power to decide the jurisdiction of such offices, and it is the central government who appoints the member, the registrar, and the power and the duties are also being conferred by the central government, and the central government can direct about the seal to be maintained by such for the registration purposes. Just remember central government. In the LLP Act, if you have there are only three authorities. If there is a pre-question comes in, there are only three authorities: central government, registrar, and deputy registrar. Directorate of Registrar, sorry. Directorate of Registrar comes only under Section 39, compounding of offence. Registrar for any communication, registration, everything. Central government is a supervisory body, so it will be under investigation, appointments, establishing any court for all those purposes. So just have those general idea and you don't have to mug up each and every uh, section. Section 69 Payment of Additional Fee. Any document or return required to be registered or filed under this Act with registrar if is not registered or filed in time provided therein may be registered or filed after that time on payment of such additional fees as may be prescribed in addition to any fee as is payable for filing of such document or return, provided that such document or return shall be filed after the due date of filing without prejudice to any other action or liability under this act. So we have seen under various provisions that the timeline has been provided, which says that you have to file this in the 15 days or you have to submit the documents in the within the 30 days. All those requirements, this section says that you can file it post the date. This section just says that such registered document or return can be filed if not registered or filed in the time you can register or file it after that time also, but for that you have to pay an additional fees. But while you are paying that additional fees, if there is any other section which provides for the penalty, that other action or liability is without prejudice, means that liability will exist. So for example, if you failed to for example, if you fail to inform registrar about change in partners. You have to do it in the you have to do it in 30 days, right? And for example, there's a penalty of 10,000. You do it on 31st day. So when you do it on 31st day, you can do it. You are not barred. It's not like you have to straight away give the 10,000 rupees. It's a maximum penalty, right? So that on the 31st day you can do it. You pay some extra fees. And along with that extra fees, if there is any liability to be incurred, that is this penalty will also accrue to you. This is what this section is talking about. Provided further that the different fee or additional fee may be prescribed for different classes of limited liability partnership or for different documents or returns required to be filed under this act or rules made thereunder. Different fee or additional fees may be prescribed for different classes of limited liability partnership for different document. Okay, and there's a saying कि if different classes के लिए different types of documents के लिए different fees होगी. ठीक है, simple. Enhanced punishment. In case a limited liability partnership or any partner or designated partner of such limited liability partnership commit any offense, the limited liability partnership or any partner or designated partner shall, for the second or the subsequent offense, be punishable with imprisonment as provided, but in case of offense for which fine is prescribed, either along with or the exclusive of imprisonment with fine, which shall be twice the amount of fine. So it is saying if you are second time you commit some offense, then is situation. Oh God. Hmm. You do a second or subsequent offense punishable with imprisonment. तो इसमें you will be imprisonment. You will be punished for 1 second. If there is a second time offense, the person shall be liable for second or the subsequent offense, then shall be liable for imprisonment. It's mandatory. Second offense, imprisonment. And in case there is a fine, the fine will be twice the amount. Application of other laws not barred. The provision of this Act shall be in addition to and not in derogation of the provision of any other law for the time being in force. Okay. The tribunal shall exercise such power and perform such function as are or may be conferred on it by or under this Act or any other law for the time being in force. Any person aggrieved by an order of tribunal may prefer an appeal to the appellate tribunal. So there is NCLT. So you can go to NCLT. Provided that no appeal shall lie to the appellate tribunal from an order made by a tribunal with the consent of the parties. Okay, this is an exception. Now, every appeal preferred in the subsection 2 shall be filed within a period of 60 days from the date on which the copy of the order of the tribunal is made available to the person aggrieved and shall be in such form and accompanied by such fees as may be prescribed, provided that the appellate tribunal may entertain an appeal after the expiry of the said period of 60 days, but within a further period of not exceeding 60 days, if it is satisfied that the appellate was prevented by sufficient cause. This is an and extension is giving plus 60 days. So total 120 days over on giving a sufficient cause. On the receipt of an appeal under subsection 2, the appellate tribunal shall, after giving the parties to the appeal an opportunity of being heard, pass such order thereon as it thinks fit, confirming, modifying, or setting aside the order appealed against it. Okay? The appellate tribunal shall send a copy of every order made by it to the tribunal and the parties to the appeal. तो अपील फाइल होगी ट्राइब्यूनल में, ट्राइब्यूनल से अपीलेट ट्राइब्यूनल में जा सकते हो। सॉरी, अपील क्यों फाइल होगी, ट्राइब्यूनल के ऑर्डर से अपील जाएगी अपीलेट एनसीएलएटी में, एनसीएलएटी इसका ऑर्डर इसको भेजेगी और पार्टीज को भेजेगी आफ्टर डिसाइडिंग द मैटर। ये 60 days में अपनी फाइल करो प्लस 60 days ऑल्सो यू हैव बीन गिवन। Section 74 General Penalties. If a limited liability partnership or any partner or any designated partner or any other person contravenes any of the provision of this Act or the rules made thereunder or any condition, limitation, or restriction subject to which any approval, sanction, consent, confirmation, recognition, direction, or exemption in relation to any matter has been accorded, given, or granted, and for which no penalty or punishment is provided elsewhere in this Act, the limited liability partnership or any partner or any designated partner or any other person who is in default shall be liable to a penalty of 5,000 rupees. And in case of a continuing contravention with a further penalty of 100 rupees for each day. After the first during which such contravention continues subject to maximum of 1 lakh. Okay, this is just a general penalty. So if there is no penalty provided in this act and there is a contravention to the provision of this act, then it's saying when there is no penalty prescribed, the penalty is 5,000. And if it still continues, then that will be 100 rupees per day, subject to maximum penalty of 1 lakh. Power of registrar to strike defunct limited partnership of the registered. Whether registrar has reasonable cause to believe that a limited liability partnership is not carrying on business or its operation in accordance with the provision of this act, the name of the limited liability partnership may be struck off when not carrying on business or operation in accordance with the provision of this act. ठीक है? In this, provided the registrar shall, before striking of the name of any limited liability partnership under this section, give such limited liability partnership a reasonable opportunity of being heard. You just remember ground, who can, registrar can, ground is not carrying the operation as per this act, and opportunity here, principle of natural justice to be followed. When an offence under this Act committed by a limited liability partnership is proved to have been committed with the consent or connivance of a partner or partners or the designated partner or designated partner of the LLP, or to be attributable to any neglect on the part of a partner or partners or the designated partner or the designated partners of that LLP, the partner, the partners, or the designated partner or the designated partners of the LLP, as the case may be, as well as that LLP shall be guilty of the offence and shall be liable to the proceed against the punished accordingly. This is just saying that LLP ने कोई offence किया है, and in that offence the partners were also a party. They committed with the consent, they committed with the connivance, or it can be attributable to such partner. Then the LLP भी liable होगी, partner भी liable होंगे. Adjudication of penalties 76A. For the purpose of adjudging the penalties under this Act, the central government may, by an order published in the official gazette, appoint as many officers of the central government not below the rank of registrar as the adjudicating officer in such manner as may be prescribed. So 76(8) talks about who will decide the penalty, who will डिसाइड क्वांटम ऑफ पेनल्टी कि अगर कोई कॉन्ट्रवेंशन हुआ है तो कितनी पेनल्टी देनी है। तो सेंट्रल गवर्नमेंट इन दैट रिगार्ड अपने ऑर्डर पब्लिश करेंगे एंड देन दे विल अपॉइंट सम ऑफिसर हु विल नॉट बी बिलो द रैंक ऑफ द रजिस्ट्रार as the adjudicating officer. The central government shall, while appointing the adjudicating officer, specify their jurisdiction in the order under subsection 1, and the adjudicating officer may, by an order, impose a penalty on the LLP or its partners or the designated partners or on any other person, stating therein any non-compliance or the default under the relevant provision of this Act, provided that in case default relates to non-compliance of subsection 3 of section 34 and subsection 135. What are 34 and 35? 34 deals with statement of solvency. 35 deals with annual return. And such default has been rectified either prior to or within 30 days of the issue of notice by the adjudicating officer, no penalty shall be imposed in this regard, and proceeding under this section in respect of such penalty shall be deemed to be concluded. अगर रेक्टिफाई कर लेते हो 30 दिन में, तुमको फाइल करने थे कुछ एनुअल रिटर्न्स एंड ऑल ऑफ दैट, अगर तुम 30 दिन में उसको रेक्टिफाई कर लेते हो देन देयर इज नो पेनल्टी. Provided further that notwithstanding anything contained in this Act, penalties payable for non-compliance of any of the provision of this Act by a small limited liability partnership or a startup limited liability partnership or by its partner or designated partner or any other person in respect of such LLP, then such LLP or its partner or designated partner or any other person shall be liable to a penalty which shall be half of the penalty specified in such provision subject to maximum of 1 lakh rupee. Now explanation. For the purpose of this proviso, the expression startup limited part means a limited liability partnership incorporated under this act and recognized as such in accordance with the notification issued. ये जो है टर्म स्मॉल लिमिटेड पार्टनरशिप तो डिफाइंड है सेक्शन 2 में बेस्ड ऑन देयर कंट्रीब्यूशन देयर टर्नओवर, बट इसमें एक और टर्म है स्टार्टअप लिमिटेड पार्टनरशिप. सो ये इसको डिफाइन कर रहा है एक्सप्लेनेशन की एक्सप्रेशन स्टार्टअप लिमिटेड लाइबिलिटी पार्टनरशिप मींस a LLP which is incorporated under this act and recognized as such by the central government. So it has not been defined, but the central government may recognize some of the incorporated LLPs as the startup LLP. Okay. So penalties कर रहे थे हम. Penalties में first clause है कि who will adjudge, who will adjudge, what would be their jurisdiction, who will appoint those officers, and then they can impose the penalties. When the penalties will not be imposed, there is some exception to it. And then we have with respect to small LLP and a startup LLP, for this the penalty will be half and maximum 1 lakh जा सकती है. This is also one exception. Then direct such LLP and its partner or the designated partner or any other person as the case may be to rectify the default wherever he considers fit for the reason to be recorded in writing. Adjudicating officer shall, before imposing any penalty, give a reasonable opportunity of being heard. Very commonsensical. Any person aggrieved by an order made by the adjudicating officer under subsection 3 may file an appeal. Appeal किसको देंगे? Important. अपील जाएगी रीजनल डायरेक्टर. तो एक और काम आ गया रीजनल डायरेक्टर का अपार्ट फ्रॉम सेक्शन 39 that they will listen to the appeal for the penalties. क्योंकि क्यों सुनेगा? क्योंकि जो एडजुडिकेटिंग ऑफिसर है दिस पर्सन इज द रैंक ऑफ रजिस्ट्रार. रजिस्ट्रार रैंक से सीनियर पर्सन इज अ रीजनल डायरेक्टर. Every appeal made under subsection 5 shall be filed within a period of 60 days. ये चलो टेंशन खत्म हुई. सारी अपील का पीरियड 60 डेज है इस एक्ट में. एलएलपी एक्ट में अपील का पीरियड 60 days है from the date on which the copy of the order made by the adjudicating officer is received by the aggrieved person and shall be in such form, manner and accompanied by such fees as may be prescribed, provided that the regional director may, for the reason to be recorded in writing, extend the period of filing an appeal under this subsection but not more than 30 days. कल यहाँ पे plus 30 days ही होगा. So if the appeal is not filed within 60 days, it can file with the period of filing such appeal can be extended for another 30 days, and this extension can be done by the regional director because that's the authority who is going to listen to or hear the appeal. Remember that appeal, which is mentioned from the tribunal to the appellate tribunal, is 60 days with the addition of 60 days. But here it is plus 30 days. That's the difference. Regional director may, after giving an opportunity of being heard to the parties to the appeal, pass such an order as he thinks fit, confirming, modifying, setting aside order appealed against. Where the LLP fails to comply with the order made under subsection 3 or subsection 7, as the case may be within a period of 90 days. What is the subsection 3 and subsection 7? Um, Rectification section, adjudicating officer. Okay. सेक्शन 3 सेक्शन 7 में पेनल्टीज इम्पोज होती हैं और एलएलपी अगर जो पेनल्टी इम्पोज हुई है उसको नहीं मानती है विद इन अ पीरियड ऑफ 90 days from the date of receipt of the copy of the order, such LLP shall be punishable with a fine which shall not be less than 25,000 but may extend to 5 lakh. तो एक एडजुडिकेटिंग अथॉरिटी आई, इसने आपकी पेनल्टीज डिसाइड की एंड पेनल्टी डिसाइड करके ऑर्डर दिया, ऑर्डर जाके एलएलपी के पास गया, एलएलपी के पास 90 days है to comply with that. If it fails, then you have to give another penalty, which will be which will start from 25,000 and can go up to 5 lakh rupees. Where a partner or the designated partner of a LLP or any other person who is in default fails to comply with an order made under subsection 3 or subsection 7, as the case may be, within the period of 90 days from the date of receipt of the copy of the order, such partner or the designated partner or any person shall be liable with imprisonment which may extend to 6 months or with fine which may be not less than 25 to 1 lakh rupees. तो ये जो क्लॉज है दिस डील्स विद एलएलपी, बट इन केस अगर ऑर्डर मेड किया है पार्टनर्स के अगेंस्ट या डेजिग्नेटेड पार्टनर या किसी एनी अदर पर्सन के अगेंस्ट एंड दे फेल टू कंप्लाई इन 90 days, in that situation they will be sent to jail 6 months के लिए, and that time period will be 6 months and or can be subject to the fine which is 25,000 or can extend up to 1 lakh. Jurisdiction. Subject to the provision contained in section 67A, 67B, that's a special court का provision. Subject to that. So, these special code overrides the section 77 also. The special code referred to in clause A of subsection 2 of section 67A shall have the jurisdiction of power to impose punishment under section 30 of the Act. What was section 30? Fraud, na? Because section 31 is holding out. And section 20, yeah. The criminal case against the LLP or its partner, designated partner, or any other person default filed under this act and pending before the court of judicial magistrate first class or metropolitan magistrate as the case may be shall be transferred to the special court referred to in clause B of subsection 2 of section 67A. अगर स्पेशल कोर्ट नहीं है तो मजिस्ट्रेट है ये हमारा मेट्रोपॉलिटन मजिस्ट्रेट, नहीं तो स्पेशल कोर्ट ही डील करेगी और उसको सारे जो भी मैटर है वो ट्रांसफर कर देंगे. 77A Cognizance of the offense. No court other than special court referred to in 67A shall take the cognizance of any offense punishable under this act or the rules made thereunder save on a complaint in writing made by the registrar or by any officer known below the rank of registrar duly authorized by the central government. तो अगर किसी एलएलपी या किसी पार्टनर के अगेंस्ट कंप्लेंट फाइल करनी है तो इट विल बी द रजिस्ट्रार हु विल फाइल अ कंप्लेंट against this LLP and that complaint will be sent to the special court in writing or by any officer not below the rank of registrar duly authorized by the central government for this purpose. So in 67A we have seen the purpose to establish those courts is for the speedy disposal. Now by reading 67, 68, 7A we got to know that for the purpose of LLP it is the special court only who has been given power in most of the cases because we want that these matter to be uh, decided decided faster and not be pending in a normal court. So those are the court which are empowered to take the cognizance. Those are the court which have the jurisdiction. And the complainant in the LLP Act is registrar. Power to alter the schedule. The central government may by notification of the official gazette alter any of the provision contained in the schedule. Who can amend? अगर ये सीने बनाया तो these are the person who can amend it. Any alteration notified in the subsection 1 have the effect as if enacted in the Act and shall come into force on the date of the notification unless the notification otherwise directs. So it is a prospective changes, but it can also be retrospective. It depends on the central government. Every alteration made by the central government under subsection 1 shall be laid. And this is again the same procedure कि ये जो है वो executive act नहीं है. This is a legislative act. It has to be passed by the both the houses. Now, power to make rules lies with the central government. What are the rules? So, clause 2 only provide for what rules can be found. Should we read it fast or should we just leave it? Because I don't think that's even important. All the rule making power lies with it. I think we should leave it. Come to section 80. Power to remove difficulty. It lies with central government, but makes such provision non-inconsistent with the provision of this act. But no order shall be made after the expiry of 2 years. दो 2 साल तक ही रिमूव कर सकते हैं डिफिकल्टीज को. Okay, that's how we complete the LLP Act.